The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. Two cases will be submitted this afternoon. Those cases are Allison versus State of Iowa, and the second case is Kelli Brewer Strong versus HNI Corporation. We'll now hear the arguments in Allison versus State. Mr. Breckenridge.
Good afternoon. May it please the court. My name is Robert Breckenridge. I represent Allison in this matter. We're here today on a application for further review that has been granted, essentially looking at the question of whether or not post-conviction counsel and their performance in the post-conviction proceedings can ever rise to the level of creating an exception to the 3-year statute of limitations that is set forth in Iowa Code Section 822.3. The facts of this case are fairly simple. In May of 2011, my client was convicted of 2 counts of sexual abuse. Appeal was taken to the Supreme Court and transferred to the Iowa Court of Appeals, where the conviction was affirmed and further appeal or application for further review was denied. Procedendo was issued on September 6th of 2012. My client then filed his first application for post-conviction review on March 6th of 2013, claiming ineffective assistance of counsel, specifically that the counsel failed to investigate and stop juror bias in the particular case. Judge Wilson of the 8th Judicial District found that the proof was lacking and that they did not know the juror's name, the relationship, if anything, to the witness, or could prove prejudice. This again was appealed to the appellate court and was transferred to the Iowa Court of Appeals, where it was affirmed on September 10th, 2015, or 3 days after the 3-year statute of limitations would have run. Procedendo was actually issued on October 21st of 2015. My client then filed a pro se application, second application for post-conviction relief, claiming ineffective assistance of counsel of both the post-conviction relief counsel and the post-conviction appellate counsel. The state then moved to set aside or dismiss the application because it fell outside of the 3-year statute and did not serve as a grounds, in fact, for the exception, which is listed under 822.3.
Can I interrupt you here? I think I know what happened there, but for you to win this case, do we have to overrule Dibble?
I think it needs to be modified, if not overruled. The reason for it is that the Dibble cases that followed and cited Dibble have risen to the point where the language is there are no instances in which post-conviction counsel's performance can ever rise to the level of making an exception. I think that falls way outside of what was required or intended by the legislature.
Dibble was decided in '96, and PCR is a function of the legislature, and they seem happy with it. They haven't done anything to change it. So, I mean, why should we overrule a case that the legislature appears to say was correctly decided?
The reason that I believe is twofold. First, I think that the language for the exception of the 3-year statute of limitations has been distorted from its original purpose. The original purpose, in my opinion, and in Justice McGivern's dissent, was to provide the individual a remedy to challenge convictions. They were going to consolidate under 822.2. They were going to consolidate all of the other remedies that were available, statutory, common law, and so forth, and allow this one piece of legislation to be the purpose or to be the function that would allow this individual to have a hearing.
But his dissent's not the law, and the law since 1996 has been, I think, just the opposite of what you've been arguing.
But I also believe that it's now time to look at that again because, in my opinion, it has been distorted. As I said before, the cases that have followed it, the unpublished opinions that are cited within the Court of Appeals opinion, and those that you shepherdized those cases, they all come to one conclusion. There is no instances in which the actions of a post-conviction counsel can rise to the level.
So what would your limiting principle be? If you say it's been distorted, where would you apply it and where would you not apply it? When could you raise ineffective assistance of post-conviction counsel, and when could you not raise? What's your limiting principle?
I think we go back to the way the language was originally interpreted under 822.3. That language that talks about grounded in fact that could not have been raised within the applicable time period. So there's two factors there. A lot of the cases since Dibble have looked at that and said, well, we're really only talking about newly discovered evidence. That's the only exception that we're really going to look at under these circumstances. And in the opinion of Justice McGivern, that was never the intent, that we were just going to limit it to
All right,
newly
I'm
discovered
still looking
evidence.
for a limiting principle.
Yes, sir. Two things. One, was it discovered or was it discoverable within the 3-year statute of limitations? The difference between the Wilkins case, in which there were multiple opportunities to discover the ineffective assistance and make those claims, or in our case, where the case we did not get that final ruling until after the 3-year statute of limitations had already expired. That would be the first limitation. Secondly, that the grounds of or facts have to be expanded beyond just the idea of newly discovered evidence. That should not be the only grounds for allowing an exception to the 3-year statute of limitations.
It isn't the only exception. We have cases that say if the law changes, that's also can be a ground that could not have been raised earlier.
I understand. I agree, Your Honor.
I'm still looking for a limiting principle. I understand your point. If it could have, if it's evidence that could have been discovered within, if it's ineffective assistance that occurred within the 3-year period, you're okay anyway. But what's your limiting principle? Because the concern I have, in addition to whether Dibble was rightly decided and whether the legislature's implicitly endorsed it, are we going to effectively end the 3-year limitation? Because you can always argue that the prior PCR counsel was ineffective in not raising whatever you choose to be raising at this point in time.
Well, I don't think that creates a burden for the trial court, because the trial court already does that every time it considers the newly discovered evidence situation. In each of those cases, they're required to make the finding that the newly discovered evidence was not discoverable before the 3-year statute of limitations, and whether or not there were actions by the appellant that led to this delay, and that they should bear the burden for having caused that delay. So I don't think it's an unreasonable burden for the trial court to do that anyway, to be able to make that determination. And as Justice McGivern says, that doesn't have to be in a full evidentiary proceedings. It can be in a summary proceedings, but it should still allow the individual to make the claim or make the case that they have not been fairly represented at post-conviction relief proceedings, and therefore they have been denied the only remedy available to them.
What bearing does the Harrington case have on Dibble?
Harrington does. Harrington specifically looks at the idea of whether or not there is a requirement for a nexus, and not only that the nexus has to be there, but you have to essentially assume the burden of showing that you're going to change the outcome. That becomes a responsibility of the appellant. Harrington says, no, we're not going to require that, and we're going to specifically reject the idea that you have to show that you essentially would win in order to set forth your claim, is the way that I interpret Harrington.
How about let's move to the second feature of the case. You filed an amended petition in the second PCR, and the claims were, as you know, that there was some recantation on newly discovered evidence, one claim, and then the second claim, I think, was change of law generally. The state says, well, you didn't preserve that claim. The district court's order is brief. It does describe the fact that you filed the amended claim. Goes on to say that it doesn't change the core nature of the petition or words to that effect, and and dismisses the entire claim. Is that good, is that good enough to preserve your additional claims?
Well, that's where the rubber meets the road. I would argue, sir, that if I had been allowed to present evidence on those issues, then I would have been allowed to flesh out exactly what we believe the new evidence to be and how we believe the law had changed. Because
No, I'm not concerned about the merits of the claim. Frankly, right now at least, I'm concerned about preservation. And on the one hand, it's clear that the district court recognized that you filed your amended motion. It doesn't really grant it. It doesn't grant it, I don't think. Then issues a very broad ruling. I mean, dismisses everything, acknowledges you filed your amended petition, dismisses everything. Is that sufficient, in your view, to preserve a claim on appeal?
I believe because the way the district court wrote their opinion, which was to neither address either of those claims and to refer back to the core basis, as it says, I believe that we have preserved that.
Let me ask this question. In the second PCR, I was kind of curious. The first claim that was raised had to do with a juror, and a juror supposedly waved at ex-spouse. But the juror was never identified in either proceeding, if I have it correctly. Not in the first proceeding, you say that was ineffective. And then in the second proceeding, the suggestion is, well, brief investigation would have revealed who the juror was and what the relationship was between the juror and the spouse, if any. But we don't even have that in the record, I don't think.
That's true because of the motion to dismiss in the district court to take it up summarily, we did not have the opportunity to do the investigation that I would have done. What we are seeking here today, Your Honors, is to prevent that automatic exclusion just because it is a post-conviction attorney who has been responsible for ineffective assistance of counsel. This being the only remedy that is available after direct appeal is done, and the legislative intent that this should be the only remedy, then you should be entitled to effective assistance of counsel. The idea that you can somehow separate them by degrees and say that trial defense counsel can be ineffective and that's one level, but if it's post-conviction defense counsel, it's a different level, seems to make an unusual distinction without any real basis in fact or practice. We would ask that you reinstate Mr. Allison's post-conviction release application, give him a chance to show that there was in fact ineffective assistance of counsel, of post-conviction counsel, and then it will be his opportunity to prove to the trial court if the impact of this potential juror's actions really had an impact on the case and requires reversal. If there are no other questions, thank you.
Mr. Breckenridge, thank you as well. Ms. Huser.
May it please the court. Counsel, 21 years ago, this court recognized that ground of fact does not include claims of ineffective assistance of PCR counsel.
Let me ask you a question here before you start. Say the first PCR counsel really blew it. I mean, if he or she would have raised the right issue, there's no question in anybody's mind that the defendant would get relief. But because he or she was ineffective, once they blow it, if you follow Dibble, you can never bring it again because the 3 years is probably gone, especially. So what relief does that defendant have other than just sitting in jail to the end of his or her sentence?
Well, I disagree with the comments that this defendant does not have options. The defendant does have options. In a PCR proceeding, it's civil. He starts with providing facts in the petition that he wants to pursue. And at the moment, he knows that counsel is not doing what he wants to do. In this case, the failure to investigate.
I'm not worried about counsel. I'm not worried about, the facts of this case may cause a different result, but I mean, it's even I could win the case if I was PCR counsel, if I would have done it right, but I just didn't do it right. And everybody in the world knows that, because this principle has to apply across the board. And then the defendant, he or she tries to bring another case, and under your position, tough luck. You had your one shot, your attorney blew it. So what relief does this defendant get? And is it right for this defendant to stay in jail or not get the relief they wanted?
I think that this general principle presumes that the defendant did nothing and had no ability to do anything in those 3 years. So let's say that, yes, counsel blew it. The defendant had three different options, at least three different options. His first was he could have requested different counsel in that 3-year period. As soon as he knew his counsel was not doing whatever the claim was, he could request different counsel.
Well,
My fact situation is that the defendant doesn't know, because it's some technical legal search and seizure issue or something like that.
Well, the PCR statute is set up that it is ultimately the defendant that has to bring facts forward. We do not require him to know any of the legal, any of the law part of it, but he has to bring the facts. So he at least has to say, the police should not have searched my car, or the police should not have done X, Y, Z. They did this in this case. And then it is, counsel is appointed to help put a legal framework to that argument, but ultimately the defendant has brought that claim forward. And as this court recognized in Gamble, the pro se applicant has extensive pro se in the sense that he can bring his own claims even if counsel is appointed. So the idea that he can just sit back and say, my attorney just did things and I just sat back and watched it happen, that's not what this statute is intended to do. I would also...
How many bites at the apple should we allow? I mean, didn't they know within the 3-year period that this juror had waved at a family member?
The defendant actually says that he knew at the time of trial that there was this waiving. He knew through appeal. He's had 4 different counsel in this case. And even if, and I would say this defendant knew that his attorney was not calling these witnesses at his PCR hearing, which was 1.5 years before his statute of limitations ran. So the claim he brings right now, he had 1.5 years left that he could have filed another PCR application. The statute assumes it is intended that a defendant can bring multiple applications within that 3-year period. So it's not that he didn't have other options. The third option, I said there were 3. The third option is that he can raise this claim on appeal from his PCR hearing. He doesn't have any error preservation problems at that point. He can say, my counsel was ineffective in PCR because they failed to call these additional witnesses. So any defendant within that 3-year period has those opportunities, but we do not have a procedure for the defendant who sits back and does not take advantage of those options available to him.
No, we have in the extreme case, which I don't think this presents, because the issue was presented and litigated once, but in the extreme case, we had the Lato case, I think it was, where we said it was structural error, where PCR counsel did absolutely nothing and let the case be dismissed. And so we also have that safety valve as well, don't we?
I think we do have that safety valve as well.
so the Dibble case might have been wrongly decided, I guess, maybe, because wasn't one of the problems in Dibble, the case was dismissed under what was then 215-1. The lawyer just kind of abandoned the case and didn't pursue it, and that was it.
I push back that Dibble was not correctly decided because Harrington did not abrogate Dibble, and I do want to point out there were 3 different rationales in Dibble, and at least 2 of those rationales are still in play here.
One isn't. It seems to me the 215-1 doesn't stand anymore.
The nexus, correct. Harrington dealt with that rationale, but we have the 2 remaining, which I would submit are actually stronger. One is the plain language of the statute, relying back on Witzel versus State, is what Dibble relies upon. And in Witzel, it was PCR counsel is not a claim that could not have been raised within that period. You know, as soon as PCR counsel is in place, you have the ability to bring that claim. So we don't need to extend that statute. And I think we have the plain language of the statute and then also legislative intent. In Dibble, this court said we are concerned with finality, with lost witnesses, with stale claims. The further away we get from your criminal trial, the less we are able to really get at the truth of these facts. And I think that is supported by the history of the statute.
So you think the legislature intended that if you got ineffective assistance at trial and ineffective assistance at PCR, and you never got an effective assistance at counsel, that'd be kind of okay?
I think they could have said in the statute that was not what they wanted. And in fact, mentioning the dissent is not the law. This case.
Not yet, but, and I do understand the thrust of your argument, but, you know, we're fishing around to see limiting principles on both ends, I think. I mean, on one end, oh my golly, we're going to have repetitive, you know, like many of the other states do. There's 3 or 4 or 5 states, Colorado, Nevada, I don't remember the rest of them, but quite a few states do allow ineffective assistance of counsel under different statutory frameworks. I mean, I don't think they're necessarily definitive on what our language is. But on the other hand, if there's a failure of counsel and somebody does not get effective representation, not only in the original appeal, but on PCR, don't you think we got a serious problem?
I do not, because I think that is what the legislature intended. I would point this court, I mean, it's the history of this statute. When it was actually adopted, the language said you can bring a petition at any time. And that was the law in this state for 14 to 15 years. And then we amended the statute in the 80s to say, no, we mean 3 years. And that was a decision. Other states have had less amounts of time. I mean, Minnesota, I think, has 2 years. Montana has 1 year, which is the equivalent of the federal. So, and I would point out that Minnesota, I believe, you aren't even entitled to counsel unless you didn't have an appeal. So I think different states are doing different things, but our state has seen the Dibble case, and the legislature hasn't acted, and I think that is legislative acquiescence to what this court decided.
Let me switch the gears to the preservation issue. The district court did not formally grant any amended petition, but he does state that the amended petition was filed, and then goes on to state some words to the effect. I mean, you know what it is, words to the effect that, well, although the amended petition has been filed, it doesn't change the core nature of the petition, or words to that effect, and then he denies everything. Well, hasn't he really, I mean, it's perhaps not really artful, but hasn't the district court ruled that the amended petition claims are dismissed under statute of limitations grounds? I mean, isn't that before us?
No, I don't believe so, because so this is governed by the civil rules. The civil rules only permit you to amend before a responsive pleading or within 20 days, whichever is applicable. So this amended petition was far past that time, but I think the defendant's solution is to file a PCR. He has, from his amended petition, what he's saying is, I have new law, I have newly discovered evidence. I do not think this is a ruling on that, and at the very least, if this defendant thought there was a ruling, that order does not rule on those claims.
And what's the purpose of the sentence that says, well, the amended petition does not change the, and again, I'm paraphrasing, does not change the core nature of the petition? I mean, it seems to me the most likely reading of the somewhat opaque district court ruling is, well, I'm going to address this on the merits. It doesn't affect the core value, that we still have the statute of limitations, bye-bye. And if so, isn't it preserved?
As I construe those petitions, it's that there are, the first petition raised ineffective assistance of counsel. The second one raised new evidence, new evidence and then new law. I think to the extent this court thinks that that was a final ruling, those two issues, not the post-conviction relief, but those other two issues would probably be a claim of new ground of fact, new ground of law. So to the extent in those three cases, I think those two issues, if this court thinks that order did address them, then that was something that would not have met the statute of limitations. So I do think that I would encourage this court to go back to Dibble and the rationales for the holding, acknowledging that Harrington did call into question that one rationale, but the remaining two rationales still hold. The plain language of the statute, this could have been discovered within that 3-year period, as well as the legislative intent. The legislature did not want these claims to be continuing for an extended period of time. I believe the limiting principle that we were talking about in this case is just the 3 years is the cutoff. That is the finality. If there is additional new ground of law, new ground of fact, the legislature has contemplated those grounds and can raise those grounds.
Let me, if indeed the alternate claims are preserved, do we send it back to the district court?
If they are preserved, I would say yes, because there hasn't been a full ruling on those two claims. But again, emphasizing it is separated into 3 claims.
I do understand that, yep.
Because the statutory rationale of Dibble was not touched by Harrington, and this defendant had the opportunity to argue that his counsel was ineffective within that 3-year period of time because he could have asked for different counsel. He had a 1.5 years.
Let me just ask a little bit about that too. You're kind of asking the defendant to be his own lawyer. He's got a lawyer who's making the presentation and so forth, and I think we can all recognize that the presentation was kind of slim, right? I mean, he called, Allison took the stand apparently, and his son took the stand, and there was a brief presentation. But an untrained person might not identify the weaknesses of that, and then of course the district court rules against him, and an appeal is taken, and he's waiting for the course of an appeal. Are you expecting the pro se litigant to be a second lawyer and kind of analyzing the case for ineffective assistance to counsel when they're not legally trained, and is that?
We are not expecting him to be second counsel, but we are expecting forward that matters. So we're not asking him to make these legal arguments, and to take this case, he knew a 1.5 years before his statute of limitations passed that his counsel was not calling these additional witnesses that he now says they should have called. And that's a fact that he knew. He was at his trial. He was involved in his appeal. He had the facts and brought them forward, and that's what we expect in the petition for post-conviction relief.
He should have leaned over and said to his lawyer, where are the other witnesses?
Well, I think he should have, he could have filed something. Anecdotally, we know that defendants are sending documents, are filing. They are not shy about saying when they are displeased with what their counsel is doing. So at the very least, he could have said at that hearing when he was given an opportunity to speak perhaps that my counsel did not investigate this claim and I need different counsel, or my counsel was ineffective. I mean, he knew at the end of that hearing or a month or so after that he lost. So
anything in the record about whether the defendant informed his first appellate counsel about this? Because, I mean, my experience is I would often be appointed to represent someone on appeal. I wasn't the trial counsel, and frequently I would get a litany of things from my client, directly from my client, about what happened at the trial and what I ought to raise and what trial counsel did and didn't do and all that. I mean, is there anything in the record about that?
There is no evidence in this record about that, Your Honor. Thank you.
Ms. Huser, thank you as well. Mr. Breckenridge, rebuttal?
Your Honors, I would just address a couple of issues. One is, I can't emphasize enough, and I know this court is aware, that post-conviction relief is highly dependent upon the counsel that they're going to receive. Many times you do the direct appeal, and the court will reserve the ruling on ineffective assistance counsel until a better record can be made, and so they reserve it for post-conviction relief. If you then are assigned an attorney who does not do the job and does not provide you with the adequate record, you're going to lose. It's not going to be a challenge at all.
But how do you respond to, the comments that we were just talking about, which is oftentimes these individuals are not shy about complaining to the PCR court, to their attorney, sending letters, or even filing their own supplemental applications. And, none of that happened in this case. And I guess what bothers me a little bit as well is then after they lose, whether he's sitting in the weeds or I'm not sure what's going on here, but then afterward, he files his own second pro se application for post-conviction relief, which is really a very artfully drafted document. I think you would agree, and it's much better than what we see from many attorneys. And so, how do we, I guess it goes perhaps back to Justice Mansfield's limiting principle. How do we cut through or decipher some of what could be legitimate ones versus illegitimate claims like this, or sitting in the weeds and then asking for another bite of the apple?
I would say, sir, that we have to do that by allowing the evidence to be fleshed out. Yes, we get these petitions all of the time that are filed supposedly by the individual. They're signed by the individual, but we all know, and we've seen them done, by the same person in Anamosa who writes all of the briefs, does all of the pleadings. So the fact that that individual may know what issues or what key phrases to argue does not mean that the individual who's now before the trial court trying to preserve his chance to show that there was ineffective assistance of counsel and therefore he was wrongfully convicted, that doesn't mean he's going to have that same ability to make those arguments. So I think that it's important that we not, in this particular case, Allison testified at the post-conviction relief hearing that he had told trial counsel about this action and nothing was done and no steps were taken. He then had a different attorney, he had the state appellate attorney do his appeal, and there was no mention of that issue at all in the appeal process. In fact, the ineffective assistance of counsel at that appeal was only argued in the alternative that the court did not find that the weight of the evidence was contrary to the verdict that was received. So it's not mentioned at all in the appeal. And so I would argue that in this particular case, his chance to flesh out this argument and to really show that it was ineffective assistance of counsel was the post-conviction hearing. And if he doesn't have a counsel who's adequate and up to the job, he's not ever going to get that chance.
But Mr. Breckenridge, I mean, I'm still waiting for that limiting principle. It does, and maybe there isn't one. I mean, your limiting principle, well, in the end, people who don't deserve to win on the merits will lose on the merits. I'm looking at the record. It seems like the evidence of guilt was pretty strong here, and I think it's unlikely your client would win on the merits when it gets there. I wouldn't prejudge it, but that's the impression one gets. If that's the only limiting principle, then you can always allege that the prior lawyer the prior PCR counsel was ineffective in some way, and there is in effect no 3-year barrier. I mean, what's the stopping point?
I understand, and I struggle with that myself. The problem is that the alternative is that we currently have in place is that all post-conviction counsel's ineffective performance is deemed never to be able to go beyond that statute. So
maybe that's what I want to focus in on then to wrap up your argument. If there is no limiting principle in the argument you're trying to make now, what have we experienced or what have we learned since Dibble, our pronouncement on the legislative intent back in 94 or 6? What have we been informed to tell us that Dibble was wrong?
I'm afraid I don't have an answer for that, Your Honor. I can't point to a specific example that we have learned, other than the fact that if we're going to continue to send matters back to PCR and indicate we're not going to view them on direct appeal, we're going to let the record be fleshed out at PCR, then we need to allow the record to be fleshed out at PCR. And if it's not adequately fleshed out because post-conviction relief counsel is inadequate, then we should be able to say that and make sure that the record does get adequately fleshed.
Or are we saying that the limiting principle really is what we've already established in Lato, which is if there's a clear structural type of error, then we've seen that as being an exception, but absent that, there isn't anything, is there?
What I would say is I have used LATO many times, attempted to use LATO many times, all without success. It's such a difficult standard to reach that we're going to have structural error. And I think that that principle is just as indefinite as arguing that we should be able to prove to the post-conviction court that there was ineffective assistance, and that prevented the appellant from presenting his full case.
Chief, if I may, Rule 19042 was a procedural option to ask the district court to rule on the amended petition that alleged new grounds of fact and law. Does the absence of such a motion mean the error was not preserved on those claims?
I took, when I was actually the post-conviction relief counsel, and my reading of Judge Gookin's sentence that indicate that that those issues didn't change the core basis left me to believe that issue was definitively decided. Thank you.
Mr. Breckenridge, thank you as well. Ms. Huser, thank you. The case of Allison versus State is now submitted, and we'll next hear the arguments in Brewer Strong versus HNI Corp.